Hello. Une fois encore, bon après-midi, mesdames et messieurs les juges, en vos grades et qualités respectives. Nous allons passer à la phase d'adoption du rapport de nos travaux. Et pour ce faire, je voudrais inviter le président Edward Babatunde, président de la Cour suprême de Sierra Leone, à monter sur le podium pour assurer la modération de cette session. J'invite le rapporteur général, M. Ghislain Agozo, et son assistante, Mme Tossine. Et Mme Tossine Goa à rejoindre le président de la Cour suprême de Sierra Leone. Et donc, nous voilà donc lancés pour la phase... Non, qu'il éteigne son micro d'abord. Éteignez le micro du président. Nous voilà donc lancés pour la phase d'adoption du rapport général. Monsieur le Président, vous avez la parole. C'est une session qui doit nous amener au plus tard à 16 heures pour le début de la cérémonie de clôture. Merci.
Good afternoon, all. My lords, my ladies, fellow participants. For the past 3 days, we have been having discussions on various topics touching on the ECOWAS court, on the ECOWAS as a body, as an institution. Those discussions have been reduced into recommendations and suggestions which we are to approve at this particular session. And there comes the presentation, adoption of the report. My information is that the report is in French. The communique, draft communique, is in English. We are not going to get the full report as of now, but the communique, draft communique, is prepared, and we are to listen to this draft communique and at the end try to approve of what has been drafted. There will be So at this particular point, I will call on the Rapporteur General, Ghislain Agozo, to begin the report and the recommendation. We need to listen to attentively because we don't have the copies at hand. I thank you.
Merci, Monsieur le Président, de me donner la parole. Monsieur le Président de la Cour de justice, Monsieur le Vice-président de la Cour de justice de la CEDEAO, Mesdames, Messieurs les juges à la Cour de justice de la CEDEAO, Mesdames, Messieurs, en vos rangs respectifs, distingués invités, je voudrais, avant de présenter le rapport, expliquer les conditions dans lesquelles ce rapport va être présenté. Le rapport est prêt en français et nous avons eu quelques soucis dans la salle pour imprimer le rapport et le circuler. parce qu'il y a eu tout à l'heure des coupures d'électricité qui ont perturbé un peu les machines dans la salle. Et nous sommes aussi sujets à des contraintes de temps. Donc, pour des raisons de commodité, je vais introduire le rapport et par la suite, laisser la parole à Madame Oluwat aussi pour présenter le communiqué final. La Cour de justice de la Communauté économique des États de l'Afrique de l'Ouest a organisé du 9 au 12 mai 2022 une conférence internationale à Praia, en République du Cap-Vert. Le thème général de la dite conférence est le modèle d'intégration de la CEDEAO, les implications juridiques du régionalisme, de la souveraineté et du supranationalisme. Il s'agit de la 9e conférence internationale organisée par la Cour après celle de Dakar en 2004, Abuja 2004 et 2007, Guinée-Bissau 2015, Bamako 2018, Accra 2011 et 2019 et Lomé 2021. Au cours de ces 47 ans d'existence, la CEDEAO a connu des avancées institutionnelles et un développement normatif perceptible au regard des réformes de ces organes dont les pouvoirs ont été renforcés. Et aussi par l'existence de droits institutionnels et d'un droit matériel important. En dépit de la richesse du droit communautaire, l'effectivité de l'ordre juridique communautaire tarde à se manifester, en raison notamment des problèmes liés à la ratification des traités, des conventions et protocoles, à la prise des mesures d'application des normes primaires et dérivées du droit communautaire dans les États membres. La non-évocation du droit communautaire devant les juridictions nationales des États membres et l'absence, jusqu'à présent, de questions préjudicielles soumises à la Cour de justice en sont les manifestations les plus ostensibles. À ces écueils s'ajoutent les problèmes liés à l'exécution des arrêts de la Cour, au respect par les États membres de leurs obligations communautaires. Ces éléments inclinent à penser que les États membres n'ont pas, dans les faits, transféré effectivement une partie de leur souveraineté comme ils s'y sont engagés, de sorte que l'on est amené à s'interroger sur l'effectivité de l'ordre juridique communautaire, car ces caractéristiques fondamentales semblent ne pas se traduire dans la réalité du processus d'intégration. C'est pourquoi la conférence de 2022 a inscrit au cœur de ses travaux les réflexions sur les implications juridiques du régionalisme, du supranationalisme et de la limitation des souverainetés nationales des États membres dans le contexte du processus d'intégration spécifique en cours au sein de la CEDEAO. À ce titre, ces objectifs sont triples. D'abord, évaluer de façon critique l'environnement juridique communautaire ainsi que l'impact du supranationalisme et des souverainetés nationales sur le processus d'intégration. Ensuite, analyser si au niveau des institutions de la CEDEAO et au niveau national, il existe un environnement juridique favorable pour le développement du droit communautaire, notamment au regard des rôles respectifs de la Cour de justice de la CEDEAO et des juridictions nationales. Enfin, identifier les entraves à la réalisation d'un ordre juridique communautaire intégré, pourtant indispensable à la réussite de l'objectif d'intégration économique régionale de la CEDEAO. Pour ce faire, une série de préoccupations ont été identifiées comme devant former la trame des interventions, notamment les questions suivantes. La supranationalité est-elle effectivement de mise à la CEDEAO? L'ordre juridique communautaire existe-t-il vraiment? Les États membres ont-ils réellement limité leur souveraineté au profit de la communauté? L'environnement est-il propice à l'intégration de la communauté? Ces préoccupations ont été abordées à travers 7 sous-thèmes que sont le modèle d'intégration de la CEDEAO, l'intégration économique régionale, la souveraineté et le régionalisme, le supranationalisme et le régionalisme, les tribunaux régionaux dans le processus d'intégration régionale, la relation entre l'intégration régionale et la protection régionale des droits de l'homme, la libre circulation des personnes, des biens et des services en tant que facteur important pour l'intégration régionale. La conférence internationale de Praia s'est déroulée dans le centre de convention de l'Université du Cap-Vert, sous une forme hybride, avec la participation de plus de 250 personnes, certaines présentes à Praia et d'autres par visioconférence via Zoom. Pour chaque sous-thème, un panel de 3 ou 4 communicateurs a livré ses réflexions sur les problématiques sous-jacentes du sous-thème. Leurs communications ont été suivies de débats ayant débouché sur des recommandations. La cérémonie d'ouverture et la cérémonie de clôture ont aussi constitué des moments forts de la conférence. La conférence a démarré le lundi. La conférence a démarré le lundi 9 mai 2022 par la cérémonie d'ouverture. Elle a été placée sous la présidence de son Excellence Dr José Maria Neves, président de la République du Cap-Vert, le président de la Cour de la CEDEAO, le président de la Banque d'investissement et de développement de la CEDEAO, la ministre de la Justice et le président de la Cour suprême du Cap-Vert ont prononcé des allocutions. Le professeur Solomon Ebobra a présenté la communication inaugurale de la conférence internationale. Je voudrais m'arrêter là et laisser la parole à Mme Oluwatosi pour présenter le communiqué final, qui reprend en substance les grandes articulations du rapport qui a été établi.
Thank you, my Lord. Good afternoon, Honorable Judges of the ECOWAS Court, Honorable Justices of the Supreme Courts of Member States, distinguished participants, all protocols duly observed. My task here is to read the final communique of the international conference that was concluded today. I'm just going to go ahead. International Conference of the ECOWAS Community Court of Justice. Theme: ECOWAS Integration Model, the legal implications of sovereignty, regionalism, and supranationalism. Introduction. The ECOWAS Court of Justice. The ECOWAS Court of Justice hosted an international conference from 9th to 12th May 2022 at the amphitheater of the University of Cape Verde, Praia, with the theme, ECOWAS Integration Model, the legal implications of sovereignty, regionalism, and supranationalism. The conference was attended by over 250 participants, some of whom were physically present in Praia, while others joined virtually via Zoom. The objectives of the international conference are to critically assess the community legal environment and the impact of supranationalism and national sovereignties on the integration process, analyze whether at the level of the ECOWAS institutions and at the national level there is a favorable legal environment for the development of community law, particularly in view of the respective roles of the ECOWAS Court and the national courts. Finally, to identify the obstacles to the realization of an integrated community legal order, which is essential for the success of the ECOWAS regional economic integration objective. Participants at the conference include judges of the ECOWAS Court, Chief Justices of the Supreme Court of Cape Verde, Ghana, Guinea-Bissau, and Sierra Leone, President of the ECOWAS Bank for Investment and Development, Commissioner of the African Commission on Human and People's Rights, representatives of member states, ECOWAS institutions and national human rights institutions, members of the academia, the judiciary and bar associations of member states, public servants of the Republic of Cape Verde, civil society organizations, students and members of staff of the ECOWAS Court. Opening ceremony. The opening ceremony of the conference on 9th May 2022 was attended by senior government officials of the Republic of Cape Verde and other dignitaries within the ECOWAS member states. His Excellency, Dr. Jose Maria Neves, President of the Republic of Cape Verde, was present to officially declare open the conference. Other dignitaries from the host government who attended the ceremony are the Honorable Minister of Justice, Madam Joanna Rosa, and the Chief Justice of the Supreme Court, Honorable Justice Benfeito Mosso Ramos. Dignitaries from ECOWAS institutions were the Honorable President of the ECOWAS Court of Justice, the Honorable Justice Edward Amoako Asante, and the Honorable Vice President and judges of the court. The President of the ECOWAS Bank for Investment and Development, Dr. George Agekum Nana Donko, representative of the ECOWAS Regional Competition Authority, and some members of staff of the court. Also in attendance were members of the Diplomatic Corps, Judiciary of Member States, presidents and representatives of Bar Association, the member states, the Academia, the President of the African Bar Association, and Director of Amnesty International. The President of the Court, as well as the representative of the Raoul Wallenberg Institute. The President of the Court delivered the welcome address. In his speech, he noted that the legal standard in most regional integration systems implies a direct applicability of community norms by member states, and the right of community citizens to invoke community norms before national courts of such integrating member states. He stressed that the member states are the most important stakeholders in the integration process, as they are recognizably sovereign, and their political will is a necessary factor for the achievement of community objectives. For this reason, stakeholders from member states have been invited to participate in the conference as the integration process revolves around them. He made a call on member states to revert to the former composition and tenure of the judges of the court, from 5 judges to 7, and from 4 years renewable tenure to 5 years renewable tenure, due to the limitation in the administration of his objectives in the administration of justice in the region. Following the welcome address by the President of the Court, the President of the ECOWAS Bank for Investment and Development, Dr. George Agekum Nana Donko, delivered a goodwill message in which he highlighted the legal barriers that
Excuse me. Could you go to the main body of the communique because of time?
Okay, sir. Okay. This means I have to go to the conclusion.
Yes.
Okay. For time, because of time constraints, I'll just go to the conclusions and recommendations from the conference. The following general conclusions and recommendations were reached by participants at the conference. So I'll start with the conclusions. That ECOWAS is an integration organization and not merely a cooperation arrangement. That the ECOWAS integration model is predominantly based on intergovernmentalism with some features in supranationalism. It's like a hybrid, and the evolution from intergovernmentalism to supranationalism has been incremental. Although intergovernmentalism and supranationalism are not mutually exclusive, as both can conveniently be accommodated in an integration arrangement, a higher degree of supranationalism is necessary in order to deepen the regional integration.
If they are numbered, please indicate the number so that participants could note those numbers. If they want to make an amendment, it will be easy.
Okay. 1, that ECOWAS is an integration organization and not merely a cooperation arrangement. 2, that the ECOWAS integration model is predominantly based on intergovernmentalism with some features of supranationalism, and the evolution from intergovernmentalism to supranationalism has been incremental. Although intergovernmentalism and supranationalism are not mutually exclusive, both can be conveniently accommodated in an integration arrangement. A higher degree of supranationalism is necessary in order to deepen the regional integration, strengthen regulatory functions, and commonality. 3, there cannot be an integration arrangement without a community. ECOWAS community citizens must therefore be given the opportunity to play a greater role in the integration process. 4, the participants commended the regional integration arrangements for ECOWAS and noted that there are obvious benefits for all the member states and community citizens in having an integration arrangement for West Africa. Although ECOWAS has not been able to attain some targets that it sets for itself, it has achieved many successes and remains the pacesetter among regional economic communities in Africa. The conference prefers to see the glass half full rather than half empty. 5, the concept of national sovereignty has evolved over time. In an integration arrangement, the integrating member states will necessarily have to cede a part of their sovereignty or delegate competencies to supranational authority created by them for the purpose of acting on their behalf in areas of their common interest. ECOWAS member states should not see this as a general loss of sovereignty, as the supranational authority, ECOWAS, only has exclusive or shared competencies with the member states in the areas of their common interest in which it has been authorized to act on their behalf. 6, that regional courts have an important role in any integration process. The focus of the ECOWAS Courts of Justice has been predominantly based on human rights because of the very few number of cases before the court in relation to the community objectives. This is traceable to the lack of or limited access of individuals to the courts in respect of the integration objectives of the community. 7, the importance of an enabling legal environment for an integration arrangement cannot be overemphasized. Law is pivotal and the fulcrum on which it is anchored. Although ECOWAS has a copious legal regime consisting of the revised treaty, numerous protocols, conventions, supplementary acts, regulations, and other subsidiary texts, it is yet to evolve into a community legal order. The community legal order should clearly manifest the legal relationship between the ECOWAS Courts of Justice and the national courts of member states, the harmonization of the legal and judicial systems of the community as envisaged in the revised treaty, the direct applicability of community norms before municipal courts, and the rights of ECOWAS community citizens to invoke community norms before national courts. 8, the conference also noted that not a single referral has been made by any national court to the ECOWAS Court of Justice as provided for by the supplementary protocol on the court since 2005, and that the national courts also have challenges in the enforcement of the judgments of the court, some of which include the non-ratification or domestication of the ECOWAS revised treaty and protocols of the court by member states. Excuse me. and the absence of national implementing legislation. Although treaties signed by member states are binding on them in the international realm, there is still a need for member states to discharge their local duty by publishing, ratifying, and domesticating the ECOWAS revised treaty in accordance with Article 5 of the revised treaty. Member states have not demonstrated the necessary political will to domesticate the ECOWAS revised treaty. 9, that the protection of human rights is a fundamental and cardinal role of the community as provided for in Article 4G of the revised treaty. The conference affirms that there is a direct relationship between regional integration and regional protection of human rights because gross human rights violations can negatively impact, derail, or destabilize the integration arrangement. Participants commended the ECOWAS Court for its bold human rights mechanism, which has received global attention, and encouraged national courts to cite the judgments of the ECOWAS Court of Justice in their jurisprudence. The conference also noted that there are obvious benefits for ECOWAS community citizens by the non-requirement of the exhaustion of local remedies, but that the court should put measures in place to avoid forum shopping that could lead to conflicts with national courts. 10, that the ECOWAS Protocol on Free Movement of Persons, right of residence and establishment is vital for the integration process of the community. The conference, however, noted with commendation that because of the protocol, there is no longer a requirement for visa in the community, but that the free movement of community citizens under the protocol is bedeviled with by many obstacles and challenges, and that the rights of residents and establishments are still subject to discriminatory practices, contrary to the provisions of the protocol. It was also noted that 14 member states are using the ECOWAS common passports, with the exception of Cabo Verde, and that 5 member states, Senegal, Guinea-Bissau, Ghana, Benin Republic, and the Gambia, have gone a step further by deploying the ECOWAS National Biometric Identity Card, NBIC, while other member states are yet to do so. It is imperative for ECOWAS member states to key into the NBIC regime in order to facilitate the mobility of ECOWAS community citizens and enhance the security architecture of the community. It is also necessary for ECOWAS member states to recognize NBIC as a travel document in accordance with the protocol. 11, the conference noted that 6 member states, Guinea, Nigeria, Mali, Burkina Faso, Togo, and Ghana, have appointed the competent national authorities for the enforcement of the judgments of the court, and that the compliance rate with the judgments of the court is about 30%, and the situation is unsatisfactory. 12, the participants observed that the reduction of the number of judges of the ECOWAS Court of Justice from 7 to 5, and the reduction of their tenure from 5 years renewable to 4 years non-renewable is also not in the interest of the courts or the community. Recommendations. 1, that due to barriers or obstacles posed by member states, the community status of ECOWAS has not fully evolved to contain integration and supranationalism. Member states are therefore urged to respect their undertakings in Article 5 of the revised treaty. Also, member states and civil society organizations should be sensitized on the need for a meaningful legal integration, and through advocacy, economic integration, and through thorough advocacy, economic integration. Sorry, I'll take that again. Also, member states and civil society organizations should be sensitized on the need for a meaningful legal integration, and through advocacy, economic integration agenda could be promoted. 2, that despite the supranational features of ECOWAS as achieved by way of successive respective treaty instructions. ECOWAS still runs on the intergovernmental model. It is recommended that the supranational features of ECOWAS should be strengthened by enhancing the powers of the Commission and granting the court the jurisdiction to hear cases filed by individuals respecting ECOWAS law. Three.
Just a minute. I see we have the recommendations here. From 1 to, it's quite a lot, 23, 20, 25. Rather than allow her to go through all of them, I will rather, she's already done the suggestions, now it's the recommendations, which should form the basis of the agreement between all of us here, the communique. We go through them one by one and ask you, rather than you forget, whether you accept it or you want an amendment, and we proceed in that. But is that agreeable to all? That is it, because not everybody has a copy. I think for them not to, for the memory not to be lost in the haze, when they hear it, I pause, do we accept it? We'll move, we'll try to move as speedily as possible, but I think it's better we get their reaction at that point rather than wait we come to the end. Any suggestion or counter suggestion? Do you quite get me what I'm saying? Yes, Mr. Vice President. Yes, sir. The microphone.
Monsieur le Président, je dis, si on veut aller recommandation par recommandation, on risque de ne pas s'en sortir.
Oh.
Parce qu'il y a plus de 25 recommandations. So, if you want to go recommendation by recommendation, stay here till tomorrow morning.
Okay. Well.
So what is better, let them meet, and every time, if you say recommendation 1, recommendation 2, not if you have a question or remark, not this one. And after you come back and say, on this recommendation, I have this remark to do.
Okay.
But it's the better way to read all of the recommendations.
Is that agreeable? Agreed. Move. Thank you.
Thank you. Thank you, my Lord. 3. Deadlines are hardly met. Deadlines are hardly met by ECOWAS, thus making the integration process expectations cumbersome. It is recommended that an early warning mechanism be set up to continuously appraise the preparedness of each member state towards targets set, with a view to assisting those not committed or making good progress to meet the targets. 4. It is recommended that ECOWAS should put in place a system to monitor the implementation by member states of community laws and to strengthen regulatory functions and commonality in order to achieve a higher degree of supranationalism necessary for integration. 5. Member states and ECOWAS should endeavor to give ECOWAS citizens an opportunity to play a greater role in the integration process by taking steps to ensure political stability and the creation of an enabling legal environment for the implementation of economic integration policies. 6. Member states, host communities, and investors should explore the dispute resolution mechanism of the ECOWAS Court in compliance with the ECOWAS Investment Code in order to enhance foreign direct investment in the community. 7. The ECOWAS current legal regime should be reviewed with the aim of ensuring the direct applicability of community texts in member states and empowering community citizens to invoke ECOWAS community laws before the national courts of member states. 8. Member states are urged to establish a peer review mechanism like the African Union peer review mechanism to monitor compliance of member states with their community obligations. 9. Member states and the ECOWAS Commission should take steps to harmonize the legal and judicial systems of the community in accordance with the revised treaty and promote synergy between the ECOWAS court and the national courts. 10. National courts of member states are encouraged to make referrals to the ECOWAS court on questions of ECOWAS community law and to make reference to the judgments of the ECOWAS court in their jurisprudence. 11. In dealing with the challenge of lack of awareness about the court and its work, the court should engage in advocacy across the community by collaborating with civil society organizations and relevant stakeholders in member states to make available to the national judiciaries and bar associations its protocols, law reports, and rules of procedure. 12. There should be frequent judicial dialogue between judges of the ECOWAS court and the municipal judges of member states. 13. Bar associations and the academia should meet frequently to exchange and share germane experiences and information on how to ensure the integration of community laws into the domestic legal system. 14. Wider participation is encouraged in the international conferences organized by the court to include breakout sessions for students, women's group, and the civil society. 15. Universities in the sub-region should include ECOWAS community law in their curriculum. 16. The court should continue its training programs for lawyers, judges, and the academia in the member states. 17. The remaining 9 member states that are yet to appoint competent national authorities for the enforcement of the judgments of the court are advised to do so without further delay. 18. The authority of heads of state and government is humbly requested to restore the composition and tenure of judges of the court back to the position it was under the 1991 protocol on the court by increasing the number of judges of the court from 5 to 7 and their tenures from 4 years non-renewable to 5 years renewable for another term of 5 years. 19. Member states should domesticate the revised treaty and protocols on the court and enact implementing legislation to facilitate the enforcement of judgments of the court by national courts. 20. ECOWAS should establish a mechanism for the effective implementation of the Protocol on Free Movement in order to ease mobility of community citizens and remove all barriers and obstacles. Member states should faithfully implement the provisions regarding the right of residence and establishment and ensure the removal of all discriminatory practices. 21. The ECOWAS Commission should ensure compliance by member states with the provisions of the Protocol on Free Movement and play the coordinating role in the implementation of ECOWAS community texts. 22. Member states should recognize NBIC as a travel document in accordance with the protocol and key into the NBIC regime in order to facilitate the unfettered mobility of ECOWAS citizens and enhance the security architecture of the community. Member states that are yet to adopt the NBIC are encouraged to do so as soon as possible. 23. For ease of communication with immigration officials and to aid the free movement of community citizens between borders, member states are urged to ensure the training of immigration officials on basic communication in the 3 languages of the community. 14. The conference recommended advocacy and sensitization of judges, critical stakeholders in ECOWAS institutions and in the member states about the provisions of the ECOWAS Protocol on Free Movement and other key ECOWAS community texts. 25. ECOWAS Commission should take necessary steps to trigger the sanctions mechanism in relation to member states that fail to fulfill their community obligations. That's all.
Thank you, Oluwatosin Ngoha. You've had the recommendations to form the communique. Do we adopt those recommendations? I hear clapping. Do we adopt those recommendations? Well, any addition, any subtraction? I still ask. Yes. Justice Kolendi.
Mr. Moderator, I see some the registrar and I these minor typos, or we should treat them as substantive. Recommendation number 1, last line. Recommendation number 1, last but one line, meaningful legal integration through advocacy, economic integration agenda could be promoted. I think we said through advocacy, social and economic integration, because we all said here that until we get to know ourselves and begin to engage as community citizens, so social is an important omission. Then recommendation Roman 3, first line, deadlines are hardly met by ECOWAS, making integration process and expectations cumbersome. It is recommended that an early warning mechanism, I think we said a monitoring and evaluation mechanism, so that we monitor and evaluate. And you can see the concept replicated in number 4. Just so, I will skip several others, but if you go to Roman XIV, which is 14, XIV, we say wider participation is encouraged, is in international conferences organized. I think we said it's recommended. That wider participation is recommended. Then the big one is Roman 15, which simply says universities in the sub-region should include ECOWAS community law in their curriculum. I think the broader concern was that the community objectives, goals, and norms should be incorporated into appropriate curriculum at all levels of community education. Because people must begin to learn and hear about ECOWAS right from the beginning, and then university, then we add it to the law schools.
rephrase that. Can you rephrase it?
My sense of it will be that community objectives, goals, and norms should be incorporated into appropriate school curriculum, and universities in the sub-region should include ECOWAS community law in their curriculum, so that we start teaching people about ECOWAS from the beginning, not at the end.
Are we in agreement of all this? Any objection? No objection. Yes, you wanted to say something. Are you too?
Just one last thing, and then I will be. Yeah. XXIV, which is the last but one recommendation. Again, the same notion. The conference recommended advocacy and sensitization of judges, critical stakeholders in ECOWAS institutions and in member states. I think is the conference recommended advocacy and sensitization of community citizens, then the judges and critical stakeholders, etc., etc. I think that will be it. I guess others may have some observations to make. Thank you. The other
Yes.
tutorials.
Mr. Vice President. My Lord, Vice President.
Merci, Monsieur le Président. Est-ce que on peut également jeter un coup d'œil sur les conclusions? Que j'ai relevé quelques observations dans la conclusion avant d'aller sur les résolutions. En ce qui concerne les conclusions, la conclusion 8, les questions que les États soient encouragés à ratifier et oui, merci, Monsieur le Président. Bon. Merci, Monsieur le Président. J'ai été soumis à un exercice pour s'adapter à la communication. Je disais que est-ce qu'on peut également jeter un coup d'œil sur les résolutions avant d'aller sur les commentaires. En ce qui concerne la résolution 8, il est marqué que les États doivent être encouragés à ratifier et à domestiquer les protocoles et autres. Je voudrais que la nuance soit portée. Ce n'est pas tous les États qui sont concernés par la ratification et la domestication. Donc, si vous globalisez, vous allez... Donc, il faut dire les États qui ont pour système une domestication avant l'application. Par exemple, nous, on n'est pas concernés par cette histoire de domestication. On en a débattu ici pendant longtemps. Donc, il faut marquer cela. Ensuite, la résolution numéro 11. Je pense qu'on a été tous interpellés dans la salle ici. Le professeur Sall, après une démonstration, a demandé est-ce qu'il peut avoir un document fiable qui atteste et justifie que l'exécution des jugements de la Cour s'est faite à 30%. Jusqu'à présent, on ne lui a pas montré le document. Donc je pense qu'aussi, on doit être prudent en affirmant ce genre de choses. Surtout qu'ici, on a parlé globalement, on n'a pas spécifié que dans les décisions de la Cour, il y a par exemple des décisions qui n'ordonnent pas une condamnation pécuniaire. Il y a des décisions qui ordonnent une restitution. Il y a des décisions qui ordonnent une remise en état. Des décisions qui demandent simplement une réparation morale. Donc tout cela, on n'a rien spécifié et on va dire que les décisions exécutées à 30%, ce n'est pas vrai, ce n'est pas justifié. Donc il faut aussi qu'on nuance ces propos-là. Ensuite, résolution, je suis maintenant dans la recommandation. La recommandation 7, il est dit qu'il faut vérifier en anglais, on met applicability. Est-ce que ça veut dire aussi en français applicabilité? Parce qu'en français, applicabilité, dire de voir l'applicabilité des textes dans les États, en français, pour le moment, ça ne veut rien dire. C'est l'application des textes. Parce que, par exemple, vous avez chié des protocoles, des traités, ils s'appliquent, c'est beau. On ne va pas venir voir s'ils sont applicables encore chez vous. Donc, ce n'est pas une question d'applicabilité, c'est une question d'application. Bon, ensuite, bon, je pense que je devrais m'arrêter là parce que je ne suis pas seul pour laisser aussi quelqu'un relever un point. Parce que si je relève tout, ce ne sera pas bon. Merci, Monsieur le Président.
I will not ask. We've noted what is said. At this particular point in time, I would ask for a motion to... Yes. Mr. Chief Registrar.
Thank you, Honorable Moderator. The figure 30% is the figure of the rate of implementation of the judgment of the courts is the figure provided by the Registry of the Courts, and we can stand by it because based on the information we have, it may not be comprehensive, but based on the limited information we have, it's 30%, and the President of the Court referred to it in his speech. Secondly, Article 89 of the ECOWAS Talk of Justice talks of ratification. It's there. Without any Article 89 of the ECOWAS Revised Treaty talks about ratification. This treaty and the protocols which shall form an integral part therefore shall respectively enter in force upon ratification by at least 9 signatory states. It's a treaty provision. Then Article 5.2 says, each member state shall, in accordance with its constitutional procedures, take all necessary measures to ensure the enactment and dissemination of such legislative and statutory texts as may be necessary for the implementation of the provision of this treaty. So these are treaty provisions, my Lord. So I advise that we leave the recommendations as contained. Thank you.
Accepted. Yes, Professor Leiden.
My Lord, Mr. Chairman, twice we gave approval to what was read. You asked us again, we gave a clap as an approval of what was read, and then you still threw back to the floor. But I think my advice, Mr. Chairman, is to please request all those who have minor corrections or any additions or any observation to please forward it actually to the Secretariat to be included. I hereby move the motion for the adoption of the communique as read. Thank you.
Do we have a seconder? Yeah, the motion is seconded. The motion is carried. Clap for ourselves. My task here is done. I think I would want to say thank you to the Rapporteur General. They had hitches, and that has stifled their production, and also the Assistant Rapporteur General. Let us put our hands together for them. And I will, at this juncture, hand over to Mr. Eric for the continuation. Thank you.
Thank you, Honorable Chief Justice Edward Desmond Babatunde from Sierra Leone. One housekeeping information. Mr. Kwasi Konan George, Mr. Amos Tubor, Adja Kumba, Christina Da Silva, Salome Bangura, Justice Desmond, Mr. Eke Metoho. Your COVID test is tomorrow morning, 10 o'clock at VIP Prayer. Kindly meet Mr. Lassisi at the end of the session. Thank you. Honorable Chief Justices, it is my pleasure to introduce to you Mr. Alindo. He has left? Okay. Arrangez correctement. It is my pleasure now to invite His Excellency the Minister of Foreign Affairs, Verde, followed by with the Honorable President of the Court for our closing ceremony. Vice-président Berigbe Ouattara, Your Excellency, the Minister of Foreign Affairs, Cabo Verde, Honorable Minister for Justice, Cabo Verde, President, Community Court of Justice, Cabo Verde, the Chief Justice, Cabo Verde, Vice President and Justice of Community Court of Justice, Honorable Chief Justice is invited, or their representatives, honorable judges, professors, and distinguished guests, the Chief Registrar and Directors of ECOWAS Court, staff members of the court, journalists, ladies and gentlemen. Today, Thursday, 12 May, comes to an end. the International Conference of Community Court of Justice, ECOWAS in Cabo Verde. Our closing ceremony will be guided as follows. We will have the vote of thanks from the Community Court of Justice, going to be read by the Vice President of the Court, Honorable Justice Berigbe Ouattara. We will have the closing statement by the Honorable President of the Community Court of Justice, and then the Minister of Foreign Affairs. We close officially our conference. On this note, permit me to invite Justice Berigbe Ouattara for the vote of thanks.
Merci, Monsieur le chef de protocole et de conférence, de m'avoir donné la parole. Il fait partie des traditions de la Cour de justice de la CEDEAO, après chaque organisation, de remercier ceux et celles qui nous ont aidés et qui ont participé à l'organisation. Nous n'allons pas faillir à cette règle. Nous allons donc procéder à la lecture de cette motion de remerciement. Mais je voulais, comme ça, dans la sagesse africaine, résumer les travaux de cette conférence par une illustration de nos sagesses. Les vieux disent que si vous ne pouvez pas devenir caméléon, il faut éviter de devenir chauve-souris. Cela ressemble beaucoup au sort de la CEDEAO, cela ressemble beaucoup au sort de la Cour. Mesdames et messieurs, considérant l'hospitalité légendaire de la République du Cap-Vert et de son peuple qui s'est manifesté à l'égard de la Cour de justice de la CEDEAO, c'est-à-dire les collègues des juges et tout l'ensemble des participants, par un accueil particulièrement chaleureux, fraternel, enthousiaste, à l'occasion de la conférence internationale de la Cour du 9 au 12 mai 2022. Considérant que cette hospitalité légendaire a été reconnue unanimement par tous les membres de la délégation de la Cour, mais également par tous les autres participants qui ont effectué le déplacement de Praia, la capitale du Cap-Vert, remarquable surtout et particulièrement par son relief touristique dans lequel la mer et les montagnes rivalisent dans l'exhibition de leurs charmes réciproques, à tel point que de nombreux participants sont tombés sous le charme et les attraits touristiques illimités de Praia et n'ont pas caché leur volonté, soit de prolonger leur séjour, soit d'y revenir immédiatement aussitôt rentrés à Abuja ou retourner à leur destination finale. Considérant les innombrables facilités faites par les autorités capverdiennes en faveur de notre délégation et les infrastructures mises à la disposition de la Cour, notamment les bureaux somptueux et surtout l'amphithéâtre de cette magnifique université, temple du savoir et de la connaissance, qui a servi de salle de conférence pour le déroulement de nos travaux, très enrichissant vu le niveau très élevé, le niveau académique des débats. Considérant la disponibilité des autorités du peuple capverdien, mais aussi leur sollicitude, leur assistance et leur générosité constante à l'égard de notre délégation et le climat de paix et de sécurité, gage de la sérénité qui a garanti le succès de nos différentes sessions. Considérant les soucis des autorités judiciaires et administratives capverdienne pour le bon fonctionnement de la Cour de justice de la communauté CEDEAO. Considérant spécialement et tout particulièrement la préoccupation constante, le souci permanent et l'indéfectible soutien de son Excellence José Maria Neves, président de la République du Cap-Vert, à l'égard de l'organisation judiciaire principale de la communauté, nous, le Collège des honorables juges et l'ensemble des participants à la présente conférence, en leur qualité et titre respectifs, saluent avec déférence son Excellence José Maria Neves, président de la République du Cap-Vert, dont le leadership est incontestable au sein de la communauté CEDEAO. En outre, nous lui rendons un vibrant hommage et lui exprimons notre profonde gratitude pour l'attention particulière et le soutien sans faille qu'il porte à la Cour, ainsi que pour son implication personnelle pour le bon fonctionnement de cet organe judiciaire et institutionnel de notre communauté, sans oublier sa présence effective qui a rehaussé d'un éclat tout particulier la cérémonie d'ouverture de la conférence. À la suite de vos remerciements du président de la République du Cap-Vert, nous adressons également nos vifs remerciements aux autorités judiciaires capverdiennes, mais tout particulièrement à Monsieur le Président de la Cour suprême, à Monsieur le ministre des Affaires étrangères et à Madame la ministre de la Justice, qui ont permis aux participants de la conférence de découvrir une autre dimension de la République du Cap-Vert. Sont également destinataires de nos remerciements les autorités et le personnel de l'université d'accueil, le président de la Banque de développement et d'investissement de la CEDEAO, de la BID, le président de la Cour suprême de Sierra Leone, les représentants du président de la Cour suprême de la République du Ghana, les hauts magistrats des juridictions de nos États respectifs, les représentants des cellules CEDEAO, les éminents et émérites professeurs de droit, les brillants avocats à la réputation et à la renommée internationale, les représentantes de Amnesty International, parce que c'est des femmes, ainsi que les représentants des autres organisations non gouvernementales et, d'une manière générale, toutes les autorités administratives, diplomatiques et judiciaires, en leur qualité et titre respectifs, qui ont honoré, soit par leur présence physique, la cérémonie d'ouverture, soit par leur implication dans l'organisation ou la tenue de la conférence internationale de la Cour. Nous associons à ces remerciements aussi le personnel local mis à notre disposition, la presse et les autres médias, le service traiteur qui s'est occupé des repas, les hôtesses qui se sont illustrées par leur discrétion et leur efficacité, les services de sécurité, les chauffeurs, etc. Un remerciement spécial est adressé au professeur Philippe Ebo Bonji Simpson, doyen fondateur de la faculté de droit, Université de Cape Coast, recteur émérite, Ghana, Institute of Management and Public Administration, qui a posé un acte fort dans le sens de l'intégration en offrant 2 bourses d'études, l'une à une fille et l'autre à un garçon, à l'université de Accra pour une période de 4 années au Ghana. Mesdames et messieurs, il serait particulièrement ingrat de ne pas remercier avec déférence les exposants, les conférenciers et les modérateurs pour la qualité de leur travail intellectuel qui constitue une véritable richesse pour la Cour. Par ailleurs, à moins de vouloir plonger le rapporteur général et les rapporteurs ainsi que le secrétariat dans un désespoir inqualifiable, il faut absolument déverser sur eux des tonnes de remerciements et de félicitations pour la qualité de l'énorme travail par eux fait, résultat de plusieurs nuits de privation de sommeil. Cette énumération n'est pas et ne peut pas être exhaustive. C'est pourquoi, dans l'incapacité de citer individuellement tous ceux qui se sont impliqués dans la réussite de cette conférence, nous souhaitons ardemment que toutes ces personnes se reconnaissent dans nos remerciements ainsi que dans l'expression de notre profonde gratitude et de notre reconnaissance infinie à leur endroit. Que Dieu, dans son infinie miséricorde, nous bénisse tous et nous couvre de sa grâce et de sa clémence. Bon retour à chacun et à chacune et à nous tous pour ceux qui voyagent. Vive la République du Cap-Vert, pays d'accueil. Vive la communauté économique des États de l'Afrique de l'Ouest, CEDEAO. Vive la Cour de justice, vive la conférence. Thank you very much. Mucha obrigado. Merci beaucoup.
Merci, honorable. Merci, honorable vice-président Berigbe Ouattara, pour vos mots de remerciement à l'endroit de toutes les personnes ici présentes. Et si jamais il en avait été omis, sachez que dans l'omission, on se rappelle que vous étiez là. Il me revient d'inviter le président de la Cour de justice de la CEDEAO, l'honorable juge Edouard Amoako Santé, pour prendre la parole au cours de cette cérémonie. Monsieur le Président.
Thank you very much. Your Excellency, the Minister of Foreign Affairs, Verde, Chief Justices of Member States and Supreme Court Judges of Member States at this occasion, Minister of Justice, Verde, Vice President and Judges of the ECOWAS Court of Justice, the professors, academia, and the resource persons at this program, presidents of bar associations and lawyers in our community who are hereby present, representatives of ECOWAS member states and directors at the various ministries who are here, invited dignitaries and our collaborators, directors, staff of ECOWAS Court of Justice, journalists, ladies and gentlemen, and staff of the University of Cape Verde. May I formally welcome you to the closing ceremony of this 2022 Praia International Conference, hosted by the ECOWAS Court of Justice in this beautiful city of Praia. After 3 days of very fruitful interaction, it is with mixed feeling that we have come to the end of the international conference that started here in Praia on Monday, the 9th of May, 2022. It has indeed been an intellectually stimulating exercise. I therefore want to express the profound appreciation of the ECOWAS Court of Justice to all our collaborators that made this possible, and to the government and good people of Cape Verde for providing a conducive environment for us to hold this event here. Permit me to single out for special mention His Excellency Jose Maria Neves, the President of the Republic of Cape Verde, for physically participating in the opening ceremony of this international conference and for declaring the conference open. The theme of the conference, as you know, ECOWAS integration model, the legal implications, the 7 sub-themes and the various issues for consideration under each sub-theme were ably discussed by our very distinguished panelists who were physically present here in the hall and a few others who did their presentations virtually. By your various contributions, you have definitely expanded the frontiers of knowledge in the various thematic areas covered by the conference. 3 days of excellent presentations by our knowledgeable resource persons, robust contributions by our distinguished participants, and cross-fertilization of ideas, we can proudly say that this has been a very fruitful and successful conference. I'm glad that there were no dull moments. We have all been enriched by the knowledge we have acquired at this conference because of the high quality of seminar papers that were presented and the quality of contributions from the floor. As stated in the concept note for this conference, the general objective of this international conference is to critically appraise the legal environment for the implementation of the regional integration agenda of ECOWAS and the impact of regionalism, supranationalism, and national sovereignties of member states on the integration process. We deliberately chose this theme and the sub-themes in order to critically analyze the ECOWAS integration model and the challenges militating against the attainment of community objectives. Your Excellencies and distinguished participants, the focus of this conference is the ECOWAS integration process, and the conference threw up many pertinent questions regarding the ECOWAS integration process with the aim of drawing attention to what the various stakeholders need to do to strengthen our integration arrangement. These include the following questions. Is there an ECOWAS model, or are we merely trying to reinvent the wheel? What is an integration organization? Is ECOWAS an integration organization or cooperation arrangement? Is the ECOWAS model one anchored purely on intergovernmentalism or supranationalism, or a hybrid of both, and etc., etc.? Is sovereignty a limiting factor, or can it be said that the concept has radically evolved over time, and when member states agreed to pooling sovereignties, was it intended to be a mere cessation of sovereignties on issues of common interest, or merely a delegation of authority? There was also the question of the enabling legal environment, the relationship between the ECOWAS Court of Justice and the national courts of member states, and the need for harmonization of legal and judicial systems in the community. Achieving an enabling legal environment without a community legal order. Okay, that's one of them. The human rights mandate of the courts and the linkage between the regional integration and regional prosecution on protection of human rights. These are all questions that were raised. We are indeed delighted that these questions were fully debated by participants at this conference, and solutions were proffered, as can be seen in the robust recommendations of the conference. It is therefore important that the member states ECOWAS Commission put in place measures to carry out the recommendations of this conference. We must emphasize that ECOWAS and ECOWAS community citizens remain the most important stakeholders in the integration arrangement. ECOWAS and its institutions therefore belong to the member states and the community citizens. A successful regional integration arrangement will therefore be to the benefit of the member states and ECOWAS citizens. We must therefore explore ways for greater engagement of community citizens in the integration process. However, we can only achieve this if there is an enabling legal environment and a community legal order. It is crystal clear that ECOWAS has indeed made a lot of progress since its establishment in 1975. Without doubt, we all need ECOWAS. There are costs to regional integration, but the benefits outweigh the costs. ECOWAS might not be where we want it to be in 2022, but all we need to do is to make it more effective. ECOWAS still remains the pace setter among regional economic communities in Africa, but we should not rest on our arse. Your Excellencies and distinguished participants, it is not in dispute that ECOWAS Court of Justice has a critical role to play in the integration process. It is therefore necessary to strengthen the court rather than weaken it. We therefore humbly urge the authority of heads of states and governments to restore the membership of the court to 7 independent judges and the tenure of judges to 5 renewable terms as envisaged in the initial protocol. Although the importance of human rights mandate of the Court of Justice is very welcoming, the community needs to focus attention on the role of the court as a community court. By expanding access to the court to community citizens on issues bordering on our regional integration, there's also the need for member states to comply with the judgments of the court, and for member states that are yet to do so to appoint competent national authority for the enforcement of the judgments of the court. In conclusion, I, on behalf of the College of Judges and staff of the ECOWAS Court, express the profound appreciation of the court to all highly valued participants here at the conference for your various contributions towards the success of this conference. I also wish to thank the President of the Supreme Court of Cabo Verde, Honorable Benfeito Ramos, a former Vice President of the ECOWAS Court of Justice, Honorable Minister of Justice of Cabo Verde, for hosting dinners in honor of the conference participants. I also tender our unreserved apology to some of our resource persons that were subjected to undue hardship in the course of their travels to this conference. The court also owes a debt of gratitude to the Chief Justices, Supreme Court judges, and all other judges and member states here present. The Honorable Foreign Minister of Verde, who is here with us at this closing ceremony. Honorable and other high government officials of Verde, President of EBID, judges of ECOWAS Court of Justice, all moderators of the various sessions of the conference, presidents and members of bar associations, international development partners, heads of ECOWAS national offices, our distinguished panelists, interpreters, translators, members of the Secretariat, the IT team, communication team, protocol team for their active participation in the conference. I also want to thank members of the press for the excellent coverage of this conference. Permit me to single out for special mention the Chief Registrar of this court and his team, who labored tirelessly for many months to ensure the success of this conference. I wish you all journey mercies back to your various destinations. Muito obrigado. Merci beaucoup pour votre aimable attention. Thank you very much.
Thank you, Honorable President Aswante, for a summary of our deliberations. Thank you. I must admit that our conference is highly honored. At the opening ceremony, we have the presence of His Excellency, and for our closing ceremony, we have the presence of the Ministry of Foreign Affairs and double presence of Madam Minister of Justice. It is my pleasure to invite His Excellency, the Minister of Foreign Affairs, Cabo Verde, to take the floor for the closing remark of the 2022 conference of the Community Court of Justice, ECOWAS, in Cabo Verde. Your Excellency.
Obrigado, Senhora Ministra da Justiça, venerando juiz, Presidente do Tribunal de Justiça da CEDEAO, venerandos Vice-Presidente e juízes do Tribunal de Justiça da CEDEAO, venerando Presidente do Supremo Tribunal de Justiça de Cabo Verde, Senhor Presidente do Conselho Superior da Magistratura Judicial de Cabo Verde, Senhoras e Senhores conferencistas, minhas senhoras e meus senhores, permitam-me, em primeiro lugar, agradecer ao venerando juiz-presidente do Tribunal de Justiça da Comunidade o amável convite que me dirigiu para encerrar esta conferência internacional destinada à reflexão sobre o tema o modelo de integração da CEDEAO, as implicações jurídicas do regionalismo, da soberania e do supranacionalismo. Gostaria de aproveitar esta oportunidade para reiterar a satisfação do Governo de Cabo Verde em empenhar-se nesta parceria que permitiu a realização com sucesso da conferência, que representa uma relevante contribuição para a contínua consolidação da nossa comunidade e de suas instituições, com destaque para o seu tribunal, um dos pilares essenciais na realização da justiça no espaço comunitário. Seja-me permitido reconhecer, saudar e agradecer de modo muito particular a indispensável colaboração da nossa distinta compatriota, a veneranda juíza Januária Costa, para a concretização desta conferência nesta cidade da Praia. Outro sim, manifestamos desde já a nossa inteira disponibilidade para participar em futuras iniciativas desta natureza que o Tribunal ou outras instituições comunitárias queiram realizar no nosso país. Momentos como estes propiciam o conhecimento mútuo tão necessário e indispensável para a integração que queremos. Cabo Verde procura uma plena integração na CEDEAO e tudo está a fazer nesse sentido, não obstante as dificuldades específicas que resultam da nossa insularidade arquipelágica e que são consideradas oportunamente a serem discutidas ao nível apropriado. Minhas senhoras e meus senhores, o comunicado que ouvimos registra o mais fielmente possível a riqueza e a diversidade das contribuições desta conferência para a concretização do desígnio de uma CEDEAO mais robusta enquanto instituição e, sobretudo, como realidade cada vez mais evidente e relevante para os nossos cidadãos, traduzindo o objetivo de uma verdadeira comunidade de povos que todos ambicionamos. A riqueza das contribuições resulta, a um tempo, da escolha assertiva do tema e dos subtemas analisados, da elevada qualificação dos oradores convidados, bem como a ativa participação dos conferencistas. A todos felicitamos vivamente. Relativamente a um largo leque de questões que vão desde o modelo de integração que temos ou almejamos ter, passando pelas implicações legais da cedência parcial da soberania num quadro de supranacionalismo em construção, pelo papel dos tribunais regionais nos processos de integração regional, incluindo a candente e complexa questão do reforço da relação entre os tribunais nacionais e o Tribunal da CEDEAO, até a proteção dos direitos humanos no âmbito da integração regional e a livre circulação de pessoas, bens e serviços, deu esta conferência um rico manancial de reflexões e sugestões que, com certeza, merecerá a devida apropriação pelas instâncias decisórias da CEDEAO e pelos demais atores que intervêm na sua transposição para o campo prático. Naturalmente, não cabe aqui retomar a análise deste leque vastíssimo de assuntos, todos de inegável relevância. Permitam, porém, insistir numa questão crucial e que tem a ver com a necessidade de reforçarmos continuamente as instituições em que assenta o Estado de Direito em todos os nossos países. As nossas instituições devem ser instrumentos de realização do bem comum, devem ser eficazes e transparentes. Só assim poderemos ter um desenvolvimento inclusivo, cheio de estabilidade e segurança. estabilidade e segurança, dois bens sob forte ameaça na nossa sub-região neste momento. E importa vincar que se os princípios da convergência constitucional estabelecidos em sede do Protocolo sobre a Boa Governação fossem respeitados por todos, teríamos hoje Estados mais fortes, servidos por instituições próprias do Estado de Direito Democrático, propiciadoras das garantias e liberdades individuais. Infelizmente, assistimos a um importante retrocesso neste domínio, situação preocupante que certamente vamos aproveitar para proceder ao desenvolvimento normativo e institucional que se impõe. Da parte de Cabo Verde, temos fundadas expectativas em que o processo de revisão do mencionado protocolo vá ao encontro desta necessidade. Neste sentido, também vai a proposta avançada por esta conferência para que se criem mecanismos de acompanhamento e avaliação dos instrumentos jurídicos adotados pela CEDEAO na busca de uma maior efetividade dos mesmos, proposta que subscrevemos inteiramente na expectativa de que por esta via consigamos a efetividade que queremos. Uma das marcas da CEDEAO tem sido a sua capacidade de adaptação à realidade. E não seria desta vez que deixaria de o fazer, e logo no momento de elevada exigência e no domínio fundamental, pois que intrinsecamente está ligado à estabilidade e segurança, logo ao desenvolvimento dos seus Estados-membros e da sua sub-região como um todo. Permitam-me, a este propósito, vincar a estreita relação que existe e deve existir entre prevalência dos Estados fortes e a afirmação do supranacionalismo. É muito difícil imaginar um Estado com instituições fracas que esteja disposto a ceder aspectos relevantes da sua soberania. No que toca à proteção dos direitos humanos, área de maior desenvolvimento da jurisprudência do Tribunal da CEDEAO, é difícil trilhar outro caminho que não o da clarificação de um quadro jurídico de salutar complementaridade entre os tribunais nacionais e o Tribunal da CEDEAO, na linha daquilo que propôs esta conferência. Minhas senhoras e meus senhores, deixo aqui uma nota de agradecimento do importante e generoso gesto do professor Philippe Bonzi Simpson, decano fundador da Faculdade de Direito da Universidade de Cape Coast do Ghana, que ontem anunciou a disponibilização das 2 bolsas de estudo para uma menina e um rapaz, para o período de 4 anos, para jovens cabo-verdianos que desejem estudar nesta prestigiada universidade. Senhor professor, pode estar certo e seguro de que esta oferta será aproveitada oportunamente. Minhas senhoras e meus senhores, permitam-me terminar desejando um tranquilo regresso a casa de todos os conferencistas que nos visitaram e brindaram com a sua presença nesta auspiciosa oportunidade, convidando-vos a voltar a Cabo Verde para melhor conhecer esta terra de Cesária Évora. Cabo Verde é uma música que as suas notas de morna e saudade continuem a soar nos vossos ouvidos atentos e nos vossos corações generosos. Declaro encerrada a Conferência Internacional organizada pelo Tribunal de Justiça da CEDEAO na cidade da Praia, de 9 a 12 de maio de 2022. Muito obrigado pela vossa paciência.
Your Excellency the Minister, with your permission, allow me to ask for recognition Professor Bonzi. Professor Bonzi, please. We will have a group picture of the high table and the honorable judges and chief justices present in the corridor when we close. For now, kindly allow me to request you to stand up for ECOWAS and Cabo Verde anthem. Thank you. We have a cocktail in the corridor offered for all. Bon retour. Merci beaucoup. Hostesses, please allow the minister and the judges to take the leave first. Kindly wait, allow the minister to take his leave first. Hostesses, please direct the minister and the high judges for the group picture. Mr. Ambo. Honorable judges, please kindly follow for the group picture. I think this time around, the photographer will find a way of taking picture for everybody. After the first group, we can take as many pictures we can. Thank you very much for participating in this conference. Bon retour dans vos pays respectifs. À très bientôt. Muito obrigado.